Wonder why the clock quit working. Do you think a battery?
Sure.
It's 2 minutes to 10. Well, when I got my phone, so I can find out what time
I
it
won't
is.
do it that way. If I do, you better,
That's why I said I had to get my phone
better
because
kick me or
not
something.
well, it says 10. It says 2 minutes to 10. So either we're too early or we're not.
It was much easier doing this kind of work when I was a lot younger and I was getting paid for it.
Really?
Well,
I'm just gonna walk out.
so Wanda, when you get the next dog? They always say if you lose one, you gotta
Well,
get one.
that's the nice thing about rescue is all I have to do is when I'm ready for the company call and I'll get a
Sure.
foster immediately.
Yeah.
So it's a good thing.
Yeah, we're on about a minute till.
Question, Mary, do we have to swear in the new members? Oh, okay.
They don't care about what they can't pay salary or do anything anyway.
Oh, okay. Oh, okay, so we can do that right after the open meeting, or it doesn't need to be done? Oh, okay.
Oh, yeah, good thing.
After, I'll be happy to come back
Okay.
and swear in.
Get 800 phone calls, not like the kid.
Okay, guess we're ready. Not sure who's supposed to sit next to you.
He didn't finish my answering my question. I wasn't any farther than
That's the new lady. Bobby just went to go chat.
You don't know if she's here.
No.
Oh, okay.
he's the sheriff and ideally, but you would be running in.
Tom, how's Tommy doing?
I think he's doing okay. He's still doing a lot of training. They keep taking him out of Fairbanks and sending him down to California for different types of training. And of course, you know, it's all secretive. They don't. He's not allowed to tell me anything. But
How old is he now?
26.
Wow.
Yeah. Now he's been promoted again. He's now a staff sergeant. So. Yeah, 5 years he's gone up like through 5 ranks.
Wow.
Let me know.
I will.
I'll leave this with you.
He's gonna make
Okay.
a career.
Sounds good. Thank you.
Talk about your son.
Yeah,
He likes the military.
yeah. I think it was a good thing for him, but it wasn't something that I was expecting when he signed up.
Well, you never know how things are gonna work out. I've got a cousin who just retired. Retired as a lieutenant colonel. He's been
Oh yeah.
had a nice career. So, you never know what things are gonna lead to.
I was just hoping he'd finish his college before he would, you know, go in.
Well, he's
But
got some opportunity in the service. If
Um,
he wa-
yeah, I'm not sure how that works.
Yeah.
But he's got a prepaid college plan, and he took advantage of 1 year before he decided that he was going to sign up. So
if he's in the Army, or
yeah, it's at Fort Wainwright, and which is in
what's his
Fairbanks.
specialty?
He's an Army Ranger, and
Oh, boy.
he's currently training other soldiers on how to survive winter situations in Fairbanks. So
Pretty good. Won't be sent in the Middle East. Of
he's
course,
already
with the Army, you never know.
he's already been to Afghanistan.
Oh, has he?
Yeah.
Yeah.
So
Oh, that's right, yeah. Well, we'll wish him. Knock on wood.
let's go.
Absolutely. We all set?
We are.
That lady's not here, so. See this guy up there? All right, ladies and gentlemen, the time is 2:03 p.m., and I'm calling to order this month's session of the Tarpon Springs Code Enforcement Board. If you have a cell phone, if you'd please either turn it off or put it into airplane mode, I'd appreciate it. And I'd like to ask Mr. Trask if you would lead us in the invocation, please.
Yes. Our Heavenly Father, send down your blessing on this meeting of the Code Enforcement Board. Give the board members a clear sense of duty and lead them to a faithful discharge of the same. Direct them in their deliberations at this meeting so that all things may be done to the glory of thy name and the welfare of the people of Tarpon Spring. This we pray. Amen.
Now the Pledge of Allegiance, please.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And I'd ask the clerk for a roll call, please.
Mr. DeMossis?
Here.
Ms. V. Casey? Here. Sorry, I got this one here. Mr. Bergerman?
Here.
Ms. Dabbs?
Here.
Ms. Wade?
Here.
Mr. Weeks?
Here.
This please your roll call.
I'll now go over the rules for the Code Enforcement Board hearing procedure. It is the intention of this board to promote, protect, and improve the health, safety, and welfare of the citizens of Tarpon Springs by providing an equitable, effective, and inexpensive method of enforcing various codes within the city of Tarpon Springs. Any aggrieved party may appeal a final administrative order of this board to the circuit court. Such appeal shall be filed within 30 days of the execution of the order to be appealed. Florida Statute 286.0105 requires any party appealing a decision of this board to have a record of the proceedings to support such an appeal. The procedure of this board is as follows. First, the city presents its witnesses and exhibits, after which the alleged violator is able to ask the city's witnesses any specific questions regarding their testimony. Secondly, the alleged violator is allowed to make a presentation and present his or her witnesses and exhibits. Then the city can question the alleged violator's witnesses. After both rounds of testimony, both on the part of the city and on the part of the alleged violator, each party is asked to give a closing argument, first by the city and then by the alleged violator. After those three steps are taken, this board will close the public hearing portion of the case to discuss it and take appropriate action. Before we begin the public hearings, we will have all potential witnesses stand up and sworn in by the secretary of the board. And again, please turn off all cell phones to silence or airplane mode. If everyone that may testify would please stand, raise your right hand. I'll have the clerk swear you in.
All right. Do you swear the testimony you're about to give is whole truth and nothing but the truth?
I do.
Thank you. Please be seated.
Thanks, everyone. Okay, the first case on the docket today is 16-8000440. Is there anyone here representing this case? All right. Sir, if you would step over there to the podium, and could you give us our name, please? Peter Vanotis, okay. Pardon me?
This is 57 West Tarpon. Okay.
Yes, okay.
It's right over there.
Thank you, sir. All right, for the city?
Anthony Mastraccio, Building Development Director, City of Tarpon Springs.
All right, sir, if you're ready, you may begin your testimony.
These are the
Thank you,
notices
sir.
that were sent to the.
This structure, 57 West Tarpon Avenue, was in violation of City Building Code 6-1 as adopted, and a multitude of codes that as you have in front of you. The initial inspection started on 9/15 of 2016.
This is the,
We've been through
how we print out.
a multitude of inspections with the fire marshal also.
No, I don't know how it's
Um,
working that.
A multitude of
Last one
meetings,
about
letters, and I'm just paraphrasing to save time, actually. But as of today,
Just a
the
moment.
fire marshal,
We need to stop for just a second. He needs to he needs to be able to hear what's going on, and obviously Barbara's got him doing something else.
Okay. Because my English is not so good. If you can help me. Okay, all right.
Are you finished, Barbara? Okay.
Anthony, I'm sorry, we had we wanted to make sure that he was paying attention to what you were saying so that he could respond if needed, so.
Would you go back over your testimony as little as it was? I want to make sure that the gentleman has a chance to hear you.
yes, sir, no problem, sir.
Go ahead.
This case is for 57 West Tarpon Avenue. It's in violation of City Building Code -6-1 as adopted, and a multitude of codes. And as I was explaining, it initially started on September 15th of 2016. And along with Captain Kenny, Fire Marshal with the city, and we performed numerous inspections at the property. We've had several meetings with the owner's engineer and contractor. And going through all the phases, as of today, at approximately 11:30 a.m., they are in compliance with all the violations as listed. However, we'd like the case to be shown in compliance, but as of today, and have them established for any repeat violations.
All right, anything else?
Yes, we also have some exhibits that we'd like to give you.
All right, before we accept them, if you would pass them down to the
Got them already? Okay.
alleged perpetrator, we can have him take a look.
He has,
He has them?
yeah, he needs
Okay.
to go through them.
Any objection with those being made part of the record, sir?
No, I have seen all of them, and I saw that, yeah,
I'll let the code board members look at them now.
yeah, let me see. Yeah, there are photos from,
I'm sorry, sir, do you have
yeah,
any
there are
objection?
photos from the place there, from 57 West Tarpon Avenue, what I have here in my front.
Sir, do you have
Yes.
any objections to them being received into evidence?
Say again?
Do you have any objection to those documents being received into evidence?
Well, I have received all of that, and I have tried to resolve all these problems.
Okay, we need to
Yeah,
just
but
concentrate
then-
on what
yeah.
the issue is right now. I want you to look at all those documents, whether
Yes.
they're photographs or documents.
Yes,
And advise us whether or not you have any legal objections to those being received by the board into evidence. And
no,
if you have a legal objection, you need to make that now. If you don't, you'll still have the opportunity to discuss each of those documents after they've been tendered.
well, I saw all of them, I agree with all of that, and what I like to tell you that I fix everything. I agree with that, yes.
Okay, so I'm going to treat that as that you have no objection to them being received into evidence.
What means that?
I need to, he said if you have no objection to
Yes.
giving them to the code board members,
Yes.
because they need to look at them.
Okay, all right. They
All
can-
right, thank you,
okay.
sir.
All of that? Okay,
I'll give them to them, I'll give you copies of the pictures.
Okay,
So
good.
that way you can look at
sorry for my English.
it. That's okay.
Okay, it's not so good.
Sir, do you have any questions for the city's witness?
Well, the only thing that they make an inspection today in the morning, and all of that, and I think they found everything under code, everything was correct. All of that you have in the photos and everything.
Okay, no questions?
No, I don't have any question.
Thank you. Any other witnesses? I'd ask, but I,
No, sir.
no, okay.
present his case if he wants.
Sir,
Yes.
do you have any evidence that you'd like to present to the board?
No.
No? All right. Do any of the board members have any questions for the city? I have a question. Can you want us to take some action even though they're now in compliance? Is this particular property have a history of problem?
We've been, yes, we've been dealing with this for some time, since 2016. So we just want to ensure all the time that we put in from that point to today, the owner actually, it's in compliance. He did everything needed. We just want to ensure that it doesn't fall back into disrepair.
Okay. So there's not a problem now. You just want a sort of a preventive
Yes, sir.
situation. All right.
What is this, a building or?
It's a motel.
Oh, okay.
Yes, ma'am. Yeah, Sunbay Motel on Tarpon Avenue.
It's down towards the bayou, right?
Yes, ma'am.
Does anyone have any questions for the alleged perpetrator?
Okay, we just need to wait until the documents come down through so that you can see the rest of the evidence.
A quick question for the city. When do you have an idea as to when these particular photos were taken?
Yes, sir. Which one? Yes. It's around September or October of 2016.
Okay, thank you. And I'd ask the clerk, as these are passed down, to please put them into evidence, part of the record.
Yes, sir.
Thank you. Do any of the board members have any questions for either the city or for the alleged perpetrator? Apparently, there's no further questions. Does anyone want to make a motion? And please bear in mind that those photos are from 2016, so those items have been corrected. this would be the first one. Sure. This is to establish a violation.
Okay.
All right, and then
You know, do they have any questions?
These are
let's do we set it.
No. If it comes back again, we do it when it comes back. Because then we can weigh, you know, how that really is.
Right, I got you. Thank you.
Is everybody sure that's the right minute?
All right, again, I believe everyone has had an opportunity to, the board to look through the evidence. Can I have a motion in this particular case?
Yes, I'll move based on the testimony, evidence, facts presented, and the law that of the time to the alleged violations, sections 304.1.1, 304.2, F 304.3, 304.6, 304.7, 304.10, 304.13, 304.13.2, 304.15, 305.1, 309.1, P 502.1, P 504.1, 505.4, 601.2, 602.2, 603.1, and 605.1 of the Code of Ordinance of the City of Tarpon Springs were in full force and effect. At the time of the notice of violations, the respondents were in violation of said code sections. However, they now are in compliance.
second.
We have a Motion and a second. Any discussion? Okay, I'll ask for a vote then.
Roll call, okay.
Roll call vote, I'm
that's fine,
sorry.
That's fine. Mr. Weeks?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs? Yes. Mr. Bergerman?
Yes.
Ms. Vaquesi?
Yes.
Mr. Demasis?
Yes.
Motion carries, sir.
Mr. Trask, would you just sum up for the claimant what the,
Yeah, I was gonna wait until after we do the supervised prosecution costs.
all right, let me ask the city, are there any costs involved in this case up to this point?
Yes, sir. There was quite a bit of time that the city on both ends, fire department and building department, has allotted to the structure.
Okay, is there a precise figure
I
involved?
have not calculated that, sir.
Okay, so they're just gonna have to make that request sometime in the future, and I'll go ahead and summarize if you'd like.
All right, then, go ahead, Mr. Trask, if you would, sir.
Sir, I just wanted to tell you what has happened here today then. The board has found that at the time of the alleged violation,
Yes. The
you
only
had
thing that
not
I-
brought the property into compliance within the time prescribed under the notice. You are now in compliance. There is no fine associated with it. However, should the property become in violation again within the next 5 years of these same exact code sections, it will be considered a repeat violation, and you'll be subject to a $500 a day fine for each particular violation.
Thank you.
So it's important to keep the property in compliance.
Yeah, thank you very much.
Thank you, sir.
Thank you.
Thank you.
Okay, the next case on the docket is 17-800000074, 709 South Diston Street, Diston. Is there anyone here for that case? All right. And sir, were you here when the clerk swore in the witnesses? All right, sir, if you'd go over here and first step up and give me your name, please.
Yes, my name is Pastor Ernest Crawford Sr.
All right.
These are set up, the photos are number 1. The notices that we sent the family is number 2. Number 3 is the administrative documents, which includes, this is the computer system that I printed out, everything that happened with the case. And then number 4 is his affidavit that he posted a sign on the front.
Okay.
And then you can look at those, and as soon as you're finished, I can get those to the third board member.
Pastor Crawford, just for my benefit, the two people listed with this property are Nathaniel and Virginia. Are you connected with them?
That's my parents.
Your parents?
My
all
mother,
right.
she's here, but my father's not. My mother.
All right.
Mr. Chairman, right now, Mr. Crawford is looking through the exhibits that I've listed for the case, just for your information. We decided to let him just get that out of the way first.
Sir, do you have any objections to those documents being received into evidence?
No, not at all. No.
Okay, thank you.
Is the city ready to present their side of the case?
Yes, sir, I am.
All right. Officer, if you're ready, you may begin.
Thank you. This is case 17-800000074, 709 South Diston. My name is Officer Gasson. I'm with City of Tarpon Springs Police Department Code Enforcement Division. This is a violation of City Code 8-40, which is the duty to maintain private property. On or about February 10th of 2017, I conducted the initial inspection of the property. This was based on, I conducted an inspection on the neighboring property, which was heard by Code Board last month. This property suffered a catastrophic failure of the ground, i.e. a sinkhole, in 2011. And it's been in 2011, 2012, somewhere around in that time. And it's been in the state that it's currently in since that period of time. You can see by the photos going around. Exhibit number 1 are all the photos that I took related to this case. The house, the structure itself is basically okay. I'm not a structural engineer, but just looking at it, it appears okay. But there's a gigantic hole in the backyard that probably 25% of the rear of the house has no dirt underneath of it, basically. And the hole's fairly substantial. So at that point in time, like I said, the initial inspection with the large sinkhole, I was unfortunately out on medical leave on February 16th, 2017, when Officer Roque re-inspected it, and obviously nothing had been done with it, and there was no change. On March 16th of 2017, the first notice of violation was issued for the property, citing a violation 8-40. It was sent, certified return receipt requested to the owner on record. Those owners were derived from the Pinellas County Property Appraiser and Tax Collectors database. On March 23rd, 2017, we received a phone call in the office requesting an extension, and we did extend that and rescheduled the inspection date for April 26th. We also received a fax from the owner on or around April 3rd, just basically reiterating the request. It was a written request for an extension. We updated the contact info about April 4th after contact with the family. And then on April 26th, I conducted a reinspection. There was no change to the property. And at that point in time, we issued a notice of hearing to be brought before Code Board. I posted the property on April 29th. And yesterday, we had a meeting with the family. Mr. Crawford's a representative of the family in an attempt to see if we could come to some sort of a resolution ahead of time. They have some fairly significant issues, obviously, with this property. It's, he can explain a little bit more, but in some, it can't, in its current state, be occupied. The family still owns the property, but it's going to take a significant amount of work to bring it into compliance. The city's issue, and one of the primary things, is safety. It does have a small chain link fence around it. It is it's about a block and a half east of Tarpon Fundamental School. It's about maybe 500 feet from Dorset Park and the Cops and Kids Center. So obviously the city's position is we're concerned about the safety of the property. And it's interesting, some of the photos, if you look at the front of the house, you really can't tell there's a giant hole in the backyard right from the street. So we're obviously concerned about a kid or somebody getting in the backyard. So for that reason, I'm asking the board to find in violation 8-40 under the dilapidated house and the property as a safety or a nuisance issue. Also, for the record, I just wanted to include exhibit number 2 were all of the notices, including the notice of hearing and notice of violation that are going around, and I request all these exhibits be placed into evidence. Exhibit number 3 are just some miscellaneous administrative documents, and exhibit number 4 is the affidavit of posting and a copy of the sign that was posted at the property. And I have nothing further at this point.
Pastor Crawford, any questions for the city?
Not really. We just wanted to basically just want to find out how much time that you all can give us to comply with what you all are asking us to do.
Okay, let me stop you, Pastor Crawford. Right now, we're in the interrogatory phase. If you have any questions, I'd like you to ask me. If not, we're going to certainly give you an opportunity before we close the proceeding to put on the record any position that you want to establish. So, but right now, we're restricted to questions. Any questions for the office?
No.
No?
Nothing. That's fine.
Does the board have any questions for the office? I have a question. Sure. Has anyone in the city made any determination as to what it would possibly take to rectify this situation?
After our discussion, the chief and I met with the Crawford family yesterday. The city's not in a position to go onto private property to do anything like that, so my observations are based strictly on that. You know, it's a giant sinkhole, and we all are fairly familiar with. You usually can't. I have asked Mr. Crawford, and I think one of the things we were going to ask for is to get an engineering certificate or certification, whether or not the property could be made viable, if you will, and keep the structure. And that's one of the things we're trying to pursue through the code board process, is to get that first step, that documentation, and then potentially go from there. If the engineering study says that the structure can't be saved, then the next step would obviously be to demolish the property and make it safe. If it can be saved, begin those steps to fix the problem. So step one is kind of the engineering survey at this point, and the city's not in a position to do that. That's not typically, for lack of a better term, our job, if you will.
Does anyone have any questions for Pastor Crawford? Oh, I'm sorry. I haven't given you a chance to present your case. Thank you very much. Pastor, if you'd like to tell us your side of the situation.
Yes, thank you. We have been trying, not even before we received the citation, well, actually over a year, we have been trying to get companies that would come, basically give us estimates on repairing the property. The family, we had decided that, we wasn't going to get the house fixed because my parents were already in another home. So we're not really looking at getting the house fixed, but to do the repairs on the property. The problem we've been having, first of all, is the finance, the amount of finance to repair it. Secondly, is trying to find a company that would take the job on. I've called and talked to probably close to 10 to 15 companies that will give estimates, looking at from the county, from the county tax, whoever's responsible for property appraisers. They'll pull up our the address, look at the home, and when they call me back, they tell us, yes, we'll come and give you an estimate on what we need to do. So I told them, well, you won't have a good picture of it. So to come out and look at it, because just looking from the road at the house, it don't look too bad. So I had every one of them to come out and take a look at it. And once they look at the home and go in the back and see the damage, the extent of it, they don't want anything to do with it. That's the problem that I've been having with almost everyone that came out. And the problem they said is that we don't want to put our equipment on that property because we're afraid we're gonna lose them, because it's not really, I wouldn't say it's a sinkhole, and the engineers and everyone else classified it as a catastrophic collapse. And a lot of them don't want to get the equipment on there, do any repairs. So that's the problem I'm having now, trying to find someone that even come and just demolish the house is what we're trying to do. And we haven't had any luck at all with that. Everyone's saying the same thing. We don't want any parts of it. If it was a regular sinkhole, we can come, we can tear it down, we can get our equipment in there, won't be a problem. But none of them, out of every one of them that called, wants to take the job on. So once we get the finances, which we've been working on, we're in the process now trying to get, we have to find someone that will come and demolish the home. We're not trying to save the home. Only thing we're trying to do is keep the property, because it's been in the family for a long time, and we want to keep the property, but we want to comply with whatever you guys want us to do also. But trying to find contractors or someone that will come and do that job, no luck at all. And I myself basically been trying, even way before the citation came out, even when it happened to my parents' house. And that's the problem we have been having, that people say, well, it's too dangerous, we're not going to bring our equipment in here, so therefore they tell us no, and I have to keep going and on. That's the problem we're having. So I don't, at this point here, we still don't have anyone that wants to do that job. See. So, and like I said, we've checked, we've got different avenues that different people we check with, and even people that buy sinkhole homes and do repairs. They're afraid, you know, like I said, if you look at that home from the front, you wouldn't think it's really that bad. But when they took half the big wash shed we had in the back and swallowed it, and took out half of you guys' road in the front, and the whole house now is splitting. There's a 4-inch split in the house if you look at it from the side. So that's why I said we're not even thinking about trying to repair the home. We're just basically trying to get someone to come and tear it, you know, demolish it and tear it down. And we haven't found anyone that want to take that job on.
Any questions from the office?
No, sir.
Any questions from the board for Pastor Croft?
I have.
Go ahead.
Did you say that you had contacted sinkhole companies? And they're telling you they won't work on it?
They would not come. If the house was tore down, okay, they may. But when they look at the house and the condition the house is in and the property, no, they don't want anything to do with it.
Is it because they're concerned that they may damage the house?
Exactly, because see, just before that happened, when we called the company out to do a drilling because my parents was experiencing some cracks that was showing up in the house, and when they sent the company out to do the drilling, they just barely, probably about a couple of minutes, got their machine out of there before it sunk, and they were doing the drilling. And I tell you, about 5 minutes after they cleared the property and went out by the road, that's when the hole fell. And at that time, that's when the shed was going down also. So by the time they got it out, their machine out, then the front part of the house in the road that took half the road out, that happened. So, you know, I mean, I can see why they wouldn't want to bring the expensive equipment in there, but I don't know what else to do. I mean, I can't tear it down myself. You know, if companies don't.
Isn't there some kind of paperwork that you can sign to hold a sinkhole company harmless on damaging the house? Or because I know they can pump from the street concrete into that hole, because that's how they're fixing the ones in other problem areas. I just wonder if you're communicating well enough to let them know you don't need the house if it gets damaged in the process of filling the hole, that it's okay because you're going to demolish it anyway.
Right. I told, you know, the ones that I've talked to come out and give the estimates, that's basically, you know, I told them, you know, the house is, we don't care anything about the house. If we can get the house towed down, you know, and then get the property be, that's another thing, because it have to be repaired, and we can't even repair the property by just putting sand in a hole. That you don't repair damage like that, just putting sand in it, because it have to be underpinned, and they have different type of gravel they put in. Because when they did the one in front of the house, the city, they hauled 30 loads of field dirt to fill that hole, and that was for dirt and shell or whatever they had to do it. So, you know, but once we get the house, if we can get someone to come and demolish the home and remove it, then we can do that next step. So, like I said, we haven't had luck trying to do that at all. So, I mean, it's not like we're not trying. We've been.
I have a question for the city, and I'm not sure, officer, if you're the right person. But are there any? And I understand it's not the city's job to rectify the situation. But is there any source of assistance in that? Is there anyone within the city that the pastor could contact that would give them and his family assistance in finding a vendor that would possibly take care of this problem?
There is, but the caveat is one the family didn't want to pursue. We presented it yesterday. We had reached out to Representative Sproles, and he advised there was a grant program that may be able to help, but in turn it would require the family sign the property over, and they'd turn it into green space. They'd basically take care of everything. They'd fix the sinkhole, and it more or less kind of turn it into a park. the family didn't want to entertain that option. They were also explained ultimately what occurs with code board and what may happen as well. So we're kind of at an impasse, but to answer your question, that was one avenue we explored. That was done in the period of about 2 days, just finding information, and it was very tentative information. So it sounds like there may be, but it sounds like the very real possibility is going to involve signing that property over, which is something at this point, kind of part of the reason I think the family's at an impasse is they don't want it, that option they don't want. So that's kind of why we're here, because I think they probably would have solved the problem many years ago if it was as simple as, here's the property, take care of it, and I'm done. So I think that's my, I mean, he could probably confirm that, but that's the impression I got.
Any
Yeah,
response to
I'm
that,
sorry.
Pastor?
Yes, well, the main, like I was saying before, the main reason for not wanting to, the deal that he was telling us about, what he was talking to us about, we like to keep the property. I mean, it's been in the family. My mom raised 5 children and so I don't know how many grandkids there at that property. Of course, that house was the first one built on Toby Acres in the early 60s. And for sentimental values, we like to keep the property, to have it in the families, because every year, that's where we have our reunions at, and we come together as a family. We're never going to build on that property anymore. We don't want to. We'll never be building on the property. But we just want to keep the property so that if we did have outings in the family, that we'll have a place that everyone can come. Just put a little throwaway canopies, little portable canopies up and do what we need to do. But keep the property in the family. And that's basically what we are hoping to have to do. Okay? And we want to, by all means, we like to at least keep the property. We don't want to have to deed it off to no one.
Well, let me ask you this question then. Everyone seems to agree that there is a problem there with this gigantic sinkhole, however you want to define it. How much time would you need to possibly rectify this situation? You've indicated that no one seems to even want to come out and take a good look at it, and no one who has looked at it wants to do anything about it. So I guess we're at a situation with unless you have some prospects as to somebody that's going to take care of it,
well,
the situation will just go on.
Right. No. Well, we're working on that, and we have a couple of companies and people that we check with that's working on possibly maybe helping us get what we need to do the repairs on it. At least another 6 months. And I think if you all can give us at least another 6 months, I think maybe something we can do to try to get back into compliance for you. Because like I said, the main thing is that once we find someone to demolish the home and tear it down, that'll be basically half of our problem of really getting it squared away. But I think if it's possible, you guys can give us, because 90 days, I really, and the only thing I can say, even with the six months, we're just going to try and do everything we can to get what we need to get that home demolished. And I'm hoping and praying that maybe someday someone would want to take that job on. Is what I'm hoping, and demolish it for us.
All right. Does anyone have any questions for Pastor Crawford? Any further questions? Go ahead, please.
Pastor Crawford, have you tried to negotiate with Ramjack?
No, I never did check. I never did negotiate with them. I know that company does do repairs on sinkhole property, damaged property, but I didn't know they were demolish homes. I was told that there's a different organization.
I don't know if they demolish homes. I know that they've done a lot of work at Mount Moriah. We've been out of the church for years.
Right.
And what I understand, they have put some 60-some loads of cement under the foundation.
Mm-hmm. Yeah, I never really reached out to them, but prior to this damage being done, I do have a regular engineering report that explained everything that need to be done to the property, but that's in case we want to get it repaired and move back into the property. You see, it's step by step on what it, what need to be done. It's like over 70 grand to do that. But no, I never checked with them yet.
Any other questions from the board? Go ahead, please.
Just so that we know that we're all doing this in good faith, could you keep a log of the places you've contacted, the dates that you've contacted,
That's no
and the
problem.
results of that?
That's no problem. I do have some. I'm sorry I didn't bring them with me. I thought I had everything in here, but I don't. But yeah, we could do that. We'll do that from here on out too.
So that we know you're doing something
Right.
and what the results.
Right. I can get you that information too.
Anyone have any further questions for either the city or for Pastor Crawford? And can I get a motion in this case? Anybody ready to make a motion?
I'll make one.
Go ahead, please.
I move based on the testimony, evidence, and facts presented in law that at the time of the alleged violation, Section 8-40 of the City Code of Ordinances was enforced in effect. The respondent was in violation thereof.
Second.
Any,
I didn't really hear what she was saying.
Pastor, the motion was made that the property be found in violation of Section 8-40. That's the motion on the floor right now.
Okay.
any discussion? Can we get a roll call vote, please?
Mr. Weeks?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Mr. Bergerman?
Yes.
Ms. Vacasie?
Yes.
Mr. DeMossis?
Yes.
Your motion carries, sir.
All right, before we go on any further, Officer Gasson, any comments or recommendations?
Yeah, through our discussions and through the city's discussions, we initially were unwilling to go 6 months. Obviously, we'll leave that with the board, but we're requesting 90 days. I completely understand the fact the family's been dealing with this for 5 years, but since it's now been brought to a position where the board's aware of the safety issue, the city's aware of the safety issue, time starts to become a bit sensitive. The city basically at this point would ask for 90 days. I also understand the financial burden, so for that reason, a fine of like $25 a day, I think is reasonable. We don't want to add to what already is going to be probably an expensive process.
Right. Any discussion among the board members? Can we get a motion?
I move that the respondent shall have until August 11th, 2017, to bring the property into compliance with Code Section 8-40 or suffer a fine of $25 per day for each day thereafter the respondent remains in violation of the said code section.
Second.
Any discussion?
We didn't hear them all.
The motion was to have the property brought into compliance by August 11th, 2017. And if it's not brought into compliance by that date, a $25 a day fine would be imposed for each day that it remains in non-compliance.
Any discussion?
I would like to say that I wouldn't have given this much time, except because Officer Gaston said he thought it would be okay to do that, because it's been going on for 5 years, and I think that money has a whole lot to do with this. Some sinkhole company would come in there and fill that hole, and I just think that it's just, I know that the cost is horrible, but it's just, they do have the option of giving up the property. And so, 5 years is a long time for that hole to be there, and it is dangerous. So I don't agree with my motion, but I made it anyway.
I would make the comment that my primary concern is that there is a potential danger with this sinkhole. It's an unfortunate situation, but there is, as a board, I think we have a responsibility to the city as a whole, and sometimes we have to make decisions that we have to take the entire city and the safety of all of its citizens into effect, even though it might be a burden on individual citizens. So that's the only comment I would make. If we're ready, can we get a vote on this motion?
Mr. Weeks?
No.
Ms. Wade?
Yes.
Ms. Dabbs?
No.
Mr. Bergerman?
Yes.
Ms. Casey?
No.
Mr. Demasis?
Yes. The motion fails. Do we have any other suggested motions in regards to this case?
I could make a new one, but it's for less time. So it's,
Well, I'm not sure that would pass. You may make it if you care to. Does anyone else have a motion in mind?
45 days feel better?
I didn't hear what you said.
Would 45 days feel better?
I would, yeah, I just would like to shorten it up some. So, okay, how about if I'll do that? Okay. So maybe around 19th of July? Okay, I move that the respondent shall have until the 19th of July, 2017 to bring the property into compliance with the code section 8-40 or suffer a fine of $25 per day for each day thereafter the respondent remains in violation of said code section.
Do we have a second?
Second.
Okay, any discussion? Well, apparently no discussion. Can we call for a roll call vote?
Mr. Weeks?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
No.
Mr. Bergerman?
Yes.
Ms. Casey?
Yes.
Mr. Demasis?
Yes,
The motion carries, sir.
motion carries.
Summarize.
Yes, if you would, please, Mr. Trask.
So, Pastor, in summary, what has happened today is the Code Enforcement Board has found a violation of Section 8-40 of the code. Your parents have until July 19th, 2017 to bring the property into compliance. Should they fail to bring it into compliance by that date, a $25 a day fine will be assessed until it is brought into compliance. Once you've got to the point that the property is in compliance, you can contact the code enforcement officer. He'll go out and he'll inspect the property, and he'll give you that affidavit of compliance once it's complete. Do you have any questions, sir?
That's not even 3 months.
About 45 days, sir.
I don't see how it's going to happen, but we'll.
Thank you. We need to move on.
Okay, our next case. The next case is 17-800000080, 1147 Toops Road, and apparently we have somebody here representing that property. Sir, if you'd give us your name.
Attorney Josh Knight for the respondent, J.P. Morgan Chase.
All right, thank you.
I'm sorry, I didn't catch your last name.
Knight, K-N-I-G-H-T.
Thank you. Sir, have you have the opportunity to review the documents? Do you have any objections to them coming in?
I do not.
evidence? Okay, thank you.
Officer Jason, if you're ready.
Thank you.
Sorry.
Case number 17-800000080. The address is 1147 Tooks Road. Property is owned by J.P. Morgan Chase Bank National Association with the registered agent of CT Corporation Systems. This is a violation of City Ordinance 8-40, duty to maintain private property. This particular case started February 14th of this year from basically a neighbor complaint. Property's in very poor condition, it's vacant. The door on the west side was kicked in. Some other issues with the structure and the property itself. I conducted an inspection on the property and I found that there were some tree issues, not providing 14 feet of clearance over the roadway, but the structure itself is in very, very poor condition. As I stated, the western door was kicked open and apparently it's become a haven for people to hang out and commit various illegal acts. So with that being said, I at the time I entered the property because the door was open and still being a police officer, I wanted to make sure there was nobody trespassing inside the structure. Inside the structure, there's a giant gaping hole in the roof over one of the rooms. Large portions of the floor are missing. Generally, the structure is just in very poor condition. The outside, as I stated, had some issues as well. On that date, we issued a notice of violation. It was sent via first class, a certified return receipt requested to the property owner and registered agent listed that were derived from the Pinellas County Property Appraiser and Tax Collectors database. On February 23rd of this year, we sent an additional notice of violation to JP Morgan Chase. We got back the letter to JP Morgan Chase unopened, not deliverable as addressed. Did some research and attempted to get another letter out to them. And I believe on February 28th, that was done with a new address. We did, however, receive the return receipt from the registered agent. Going on, another inspection was conducted on April 8th, because we had some discussion with a representative of the company that they were working on, trying to get bids and things like that. Some of the outside of the property has been cleaned up a little bit, but we still have a continuing problem with the door being secured. And then as you can see in the pictures, the holes in the ceiling, the holes in the floor, just the general poor condition of the property. I had initially started to go down a path of requesting the city possibly look at it from the building inspector side for demolition of the property. We at this point in time kind of backed away from that, brought it back over into the owner's position to bring the case before Code Board for a couple of issues that I'll discuss here in a minute. Continuing on, April 17th, a notice of hearing was mailed first class and received on April 20th an email from Amber Stone, who's a representative of JP Morgan Chase. So they were made aware of the notice of hearing. I posted the property on April 29th, and we have had numerous phone calls and emails with April. Obviously, since the council's here representing the property, they were aware of the situation. I conducted my final inspection on May 10th, and it's still not in compliance. And basically, what the city is asking for is a violation of 8-40, which is the nuisance ordinance for the very poor condition of the structure itself and the property. And then at some point asking the owners to either demolish it or continue with the remodel, which council and I have talked briefly about that, and apparently there is a plan in place that they have in motion. They're just dealing with getting bids and some other things like that. So we're, the council, and he can advise, doesn't really have any objection to the property being in violation. He just, again, needs a little bit of time to try to deal with that. So that's all I have at this point.
Well, let me ask, do you have an opinion as to, you said he needs a bit more time according to his discussions with you. Have they indicated how much time, and does the city have any opinion about that?
No, we don't. I've met with some folks out on the property, and council they've obtained a lot of their certificates and preliminary stuff. I think it's just locking down bid process. We discussed 60 days, which from the city standpoint, the only thing I ask for them is if they can get out and secure it, which we'll be able to take care of today. I'll email them again. And they've been pretty respondent about trying to keep it secured. It's just people kick it in, and, so we have to continually check on it. But the 60 days seem reasonable, especially since most of the process is in place. And they're going to make the determination to whether demolish it or pull building permits and bring the structure up to where it's an occupiable building.
Councilor, any questions for the city?
No, Mr. Chairman, I spoke with the officer prior to the hearing. We seem to be on the same page.
Thank you. Does anybody on the board have any questions for, oh, I'm sorry. Your turn. And I can't believe I shut off a lawyer from.
No, it's quite all right. I'm
being
used
given
to
an
it.
opportunity
Definitely
to
used
speak.
to it. So I would just ask that the city would consider the officer's recommendation. My clients have been more responsive than they have been in the past. Certainly, we're unaware of the immediacy of the nuisance, especially with the door. I plan on communicating that to my client following this hearing. We'll make sure that they have a rotating vendor come out there to check it periodically to make sure that it doesn't get broken, and if it is broken, then we'll remedy that. They have obtained engineering reports, pulled certificates. It is, to my knowledge, their intent to rehabilitate the property at this time. That may change down the road, but I do think that once the report has been generated and a vendor has been selected, sometimes it requires them obtaining multiple bids from multiple vendors. It's just time. But once that gets nailed down, it's a relatively quick process to rehabilitate the property. So I'm confident that 60 days at this time is sufficient.
All right, so you agree that the 60 days estimate that the city gave is something that your
Yes, Mr.
client can work with? All right. Does anybody have any questions for the city or any questions for the council for the property? Any questions for the city first?
Have they been paying?
Can you speak up if you're going to ask a
Yeah,
question?
speak right into the microphone there.
Have these fines been collected during this time period, starting in September of 2014?
The responses?
On your cover sheet, you list 2 prior code board orders, and the board member is asking whether or not the city has been collecting fines on the 2 outstanding cases.
The 2014 case had been paid, and the 2016 case is not collecting dailies, but it does have a standing fine. So it was previously, the property had been in violation previously, and it had accrued fines. And JP Morgan Chase is aware of those fines existing as well. And I'd have to confirm with the clerk. I think there may be a lien on the property, but I'm not sure about that.
I believe there is one existing lien at this time.
Okay, so there is a lien on the property.
Yes.
Anyone have any further questions for either the city or the representative of JP Morgan Chase? Apparently no further questions. Can we get a motion in this case?
Yeah, I move based on the testimony, evidence, and facts presented in law that at the time of the alleged violation, Section 8-40 of the Code of Ordinance of the City of Tarpon Springs was in force and effect. The respondents were in violation thereof.
Second.
Any discussion? Can we get a roll call vote, please, from the clerk?
Mr. Weeks?
Yes.
Miss Wade?
Yes.
Miss Dabbs?
Yes.
Mr. Bergerman?
Yes.
Miss Vacacy?
Yes.
Mr. Demasis?
Yes. Before we go on to the potential penalty, Officer Geisen, any comment that the city would like to make?
As we discussed, the 60 days, previously in April 1st of 2016, the board found $100 for each day the violation continues to exist. So the city would just stand with that same fine, 60 days and $100 per day, if not in compliance.
Can I get a motion in regards to this case?
Yeah, I move that the respondent shall have until June the 11th to bring the property into compliance with, not June, July 11th, excuse me, this is May. And to bring the property into compliance with code sections 8-40 or suffer a $100 per day fine for each day thereafter the respondent remains in violation of said code section.
Any second? Any discussion? Can we go have a roll call vote, please?
What was the compliance date? I'm so
$100.
No, July 11th.
Oh, July 11th.
July 11th, $100 fine thereafter.
Mr. Weeks?
Yes.
Ms. Wade?
Yes.
Mrs. Dabbs?
Yes.
Mr. Bergman?
Yes.
Ms. Casey?
Yes.
Mr. DeMoss?
Yes.
You want me to summarize?
Go ahead, if you would, Mr. Trice.
Mr. Knight, in summary, then the property owner has been found in violation of Section 8-40 of the city's code. Property owner has until July 11, 2017 to bring the property into compliance, or the property owner will suffer a $100 a day fine. Once the property is in compliance, your client or you can call Officer Gassinen. He'll go out and inspect the property, give you that affidavit of compliance, will be considered by the board at the next meeting following the compliance date.
Very good.
Any questions?
Sure.
Okay, thank you.
Thank you.
Thank you.
All right, that brings us to our next case. It's 17-800000096. Anyone here for this case? All right. Gentlemen, if you could give us your names, please.
Yes, sir. I'm Larry Crow, 1247 South Pinellas Avenue, attorney for the tenant.
All right. And you, sir?
Dave Lewis.
Dave Lewis. Thank you.
Yes, sir.
Barbara, did you already hand Mr. Crow the documents?
She did. We've reviewed them.
Okay, any objections?
No, sir.
Okay, thank you.
Okay, before we go any further, though, it's indicated John and Stella Merritt. And I understand Mr. Crow is the attorney, but what's Mr. Lewis, what's your position in this?
If I may, Mr. Chairman, I do represent Dr. and Mrs. Merritt. They're the owners of the property, but Mr. Lewis is here because he's the tenant and the one responsible. So I represent them all. I guess I misspoke. Yeah.
Okay, that's fine. I just wanted to check everybody's standing. Thank you.
Yes, sir.
Have you had an opportunity to look at the exhibits?
Yes, sir.
All right, and you have no problem with those going into evidence?
No, sir.
No, okay. Then I believe we're ready. Officer Gaston, if you're ready.
Thank you, yes. Case number 17-800000096, property address 438 Riverside Drive. John and Stella Merritt are the listed property owners. Case before you today is a violation of City Code 8-22, which is the accumulation of trash on private property. 8-52, which are nuisance prohibitions that go with trash and debris and other things. And then City Code 36.03, which deals with fences, walls, and hedges. Presented before the board were 4 exhibits. Exhibit number 1 were all the photographs that I've taken in relation to this case. Exhibit number 2 were all the notices, including the notice of violation, an amended notice of violation, and a notice of hearing, and the certified return receipts. Exhibit number 3 are any miscellaneous administrative docs, the property appraiser and tax collector's records, and emails, correspondence between the city and anybody related to the property. And finally, exhibit number 4 is the affidavit of posting and copy of the signs. And Mr. Chairman, I request that those 4 exhibits be placed into evidence for the record.
And I would ask the clerk, as these are passed down, if you would please place them into evidence.
Yes, sir.
Thank you.
Mr. Chairman, on February 22nd of this year, I conducted the initial inspection of the property. It stemmed from dealing with the property that's directly north of it, had a violation on that property where it was overgrown. That property was cleaned up, and then simultaneously, because of the cleanup, this property became visible. A large number of the photographs that were passed around are taken from the north of the property, and you'll see kind of a vacant lot in between there. That was the vacant lot that was a previous case that made this property visible. At that time, I noticed numerous violations. The boat that's acting kind of along the property line, fence-like-ish, as a blockade, large amount of trash and debris. The definition of debris under 852, which is actually under a different part of the city code, debris is very broad in the sense it talks about old unused equipment. It even specifically mentions boats that aren't being used. It mentions trailers. It mentions a myriad of things that are on the property that just are left there. In the case of 438 Riverside, there's also a large tarp that's extending over the rear of the property, almost acting as if a structure or covering up a large amount of debris. I don't want to necessarily insult anybody and call it trash, but things that are there that probably shouldn't be there, for lack of a better definition. As I stated, the fence is also in very poor condition. It's missing in some places. It's being supported by stakes. Initially, I sent the violation out, and I did do an amended violation, and the reason why it was specifically to include the fact that extensions were on the fence that took its height over 6 feet, which is a violation of the city code. One thing that should be established about this property is it is in a residential zone. Although some of the activities that are occurring there would be allowed in a commercial area, this is a residential area, so storage of all the boats and all those kind of things is where part of the issue comes in. Continuing on, as I stated, there's a definition of debris in here, and you can certainly read through it if you want, but it covers a myriad of items which seem to be on the property there. On February 22nd, a notice of violation was mailed first class and return receipt requested to the owner of record and the tenant. The owner of record was derived from the Pinellas County Property Appraiser and Tax Collectors Database. And then, as I stated, we've had prior cases with Mr. Lewis, so we knew he was a tenant of the property, sent him a notice violation as well. The certified letter was signed by John Merritt on February 22nd, and that was received. I conducted a reinspection on March 15th. That was actually conducted by Officer Berg because, again, I was out for a medical issue. There was, the boat remained, and there was still basically not in compliance at that time. On April 12th, I conducted a reinspection. It was still out of compliance. And that point was when I issued the notice of violation amended, adding the addition to the 6-foot fence sections there. It was mailed first class, return receipt requested again to the owner and to the tenant occupant. We returned certified receipt signed by John or Stella Merritt out of Tampa. And then I conducted another reinspection on April 26th, and there appeared to be no change. It still wasn't in compliance. There may have been things going on, but I couldn't see them. Notice of hearing was issued, mailed first class, return receipt requested to the owner and tenants on April 26th. And we received an email from Mr. Lewis requesting an extension on around April 28th. He's respectfully requesting an extension, and I have a feeling that part of the reason why he's here is probably to ask for an extension, but I won't get into that. He advised via an email that he's been steadily working on the property. Should be noted, it's been that way for quite a while. I just discovered it, that backside. I could never see it prior to that, but property's basically been in that state I've been in this position for about 2 years. So it's probably roughly about 2 years it's kind of been in that state. But it was never brought to the forefront because of the property to the north of it. I posted the property on April 29th of this year, and on April 2nd, we did receive the certified receipt for the notice of hearing, and I conducted a final inspection yesterday on May 10th, and it was still not in compliance. And at that point, I have nothing further. Or at this point, nothing further.
Counselor, any questions for the city's witness?
No, sir.
Mr. Lewis, any questions?
No, sir.
Do any of the board members have any questions for the officer?
I have one question. Mr. Gasson, your testimony was that you received the return receipt on April 2nd, 2017. Was it actually May 2nd, 2017? Did you just misspeak on that? I just want to make sure the timing of it, because the notice of hearing was mailed on April 26th.
That is correct. Sorry, I'm sorry, I said it again. It's
May
May 2nd,
2nd.
2017 that
Okay.
the certified NOH was received.
Okay.
I have a question for you, officer.
Yes, sir.
Based on your last inspection, was there any improvement in the situation from previous inspection?
From my perspective, which you can appreciate, there's still fences and stuff. I couldn't see anything that was abruptly obvious.
All right.
Is there a house on that property too?
Yes, ma'am, there is. And Mr. Lewis lives in it.
Oh, okay.
Does anybody on the board have any questions for Mr. Lewis? Oh, I'm sorry. Keep trying to cut things short. And again, it's for some reason, it must be Freudian. I keep cutting the lawyers off from an opportunity to speak. So, if you would, Counselor Crowe.
I think, Mr. Trask, and I understand the implication. If I may, Mr. Chairman, I'm here on behalf of all parties. Mr. Lewis is acquaintance of mine for many years. He's been living in the property for approximately 10 years. All the stuff inside the fence is an amalgam of things he's been collecting and trying to make his life better for that period of time. As Officer Gasson stated, and we have no objection to anything he said, that the particular event that happened on February 22nd, the tree coming down, exposed everything. I would tell you that since that time, even though the exterior still looks the same, Mr. Lewis has been attempting to starting to remove these things. There's, like I said, it's an amalgam of actually 10 years worth of stuff. He is on complete disability. He does understand the issue of the aesthetics of the fence and the safety of the fence regarding the 6 feet of height and the stakes that are utilized there. He understands that's got to be a priority. He just needs more time. He had spoken to Officer Gasson about that. He was informed, of course, that this board would be the only one that can grant any type of extension.
Right. And Mr. Lewis, anything you want to add to that?
No, sir.
Sorry.
You could just swing on it. It's not,
It's all right. Mr. Lewis, since apparently you're going to have to do most of this work, do you have any estimate as to how much time it's going to take you? Your counselors indicated there's a lot of accumulation of items there.
Yes, sir. If I could get 90 days, I'm sure you guys would be happy after that.
90 days.
Yes, sir.
All right. Let me turn to the city's representative. You've heard Mr. Lewis indicate that and give us an assurance that if he gets a 90-day extension, any thoughts on that request?
That would have been my initial suggestion was going to be 90 days. So
Right,
that
so you have-
made life easy.
All right, so you're not in disagreement. You're
No,
actually,
I'm not.
Okay. That might make it a little easier for the board. Does anybody on the board have any questions for either Officer Geisen or for Mr. Lewis or Counselor Crowe? No questions? Can I get a motion in this case?
Yeah, I move based on the testimony, evidence, and facts presented in the law that at the time of the alleged violations, sections 8-22, 8-52, and 36-03 of the Code of Ordinance of the City of Tarpon Springs was in force and effect. The respondents were in violation thereof.
Second.
All right, we've got a motion and a second. Any discussion? Can we get a roll call vote then, please?
Mr. Weeks?
yes.
Mrs. Wade?
Yes.
Mrs. Dabbs?
Yes.
Mr. Bergerman?
Yes.
Ms. Vacasie?
Yes.
Mr. Moses?
Yes. All right, the first motion having passed, I would turn to the city. Any comments in regards to any potential penalty in regards to this case?
Yes, sir. Pleases the board. As I stated, I have no objection to 90 days. I think that's a reasonable period of time. The board, Mr. Lewis, and the city have had a long-standing relationship for a few years with some violations previously. So for that reason, just because of the prior issues, I would ask the board consider $150 a day fine after that period of time.
$150 a day is your recommendation. Does anyone want to make a motion?
Yeah, I move that the respondent.
All right, we've got a motion. Go ahead, please,
I would
ma'am.
like to make a motion to that effect, yeah.
Go ahead, please.
So there's a form motion
By
here.
wording.
Right at the bottom. That would help.
What was the date?
Well, you have to pick that date, but the
90 days.
90
recommended
days is
90,
what is
recommended
recommended.
90.
August
You have
11th.
a calendar? Okay. She's got one. She found it. Okay.
I move based on the testimony, evidence, and facts presented in law that at the time of
It's the
second
second,
one,
Second
it's
one.
the second one,
that
the
the
lower one.
respondent shall have until August 17th to bring the property into compliance with code sections 8-22, 8-52, 36.03, or suffer a fine of $150 per day for each day thereafter the respondents remain in violation of said code sections.
I'll second it.
Okay, any discussion? I would just suggest that $150 is a bit of a stiff fine, but based on the testimony of Officer Geisen, that there has been a lot of interaction with the people involved with this case, I don't necessarily think it's inappropriate, although it's somewhat high for what we normally use, but I think that the city has presented its position to support that cost. If there's no other comments, we'll ask for a roll call vote on the motion.
Mr. Weeks?
Yes.
Ms. Wade?
Yes?
Mrs. Dabbs?
No.
Mr. Bergerman?
Yes.
Ms. Vacasie?
Yes.
Mr. DeMossis?
Yes. Motion passes. And if you would, Mr. Trask, please sum up for the counselor and for Mr. Lewis.
Mr. Crowe, your clients have been found in violation of sections 8-22, 8-52, and 36.03, and given until August 17, 2017 to come into compliance. Should they fail to come into compliance by that date, a $150 per day fine will be instituted. Once the property is brought into compliance, you can have your client contact Mr. Gasson, and he'll come inspect the property to give you that affidavit of compliance.
Thank you, sir.
Thank you.
Thanks. Okay, we'll move on to our next case. It's 17-8000000148, 322 East Lime Street. Anyone here for 322 East Lime Street? All right. If you would.
They're a different address. You guys are 119 East Lime Street. Right. This is a different address.
This is 322. 322, sir.
Okay.
Okay, so that's not your address, right?
No.
Okay. This case that we're gonna do now, just so that there's no misunderstanding, is 322 East Lime Street, the estate of Ruby Brooks, and apparently there's no one here for that, for this case. Officer Geisen, if you are ready to present the
Keeps
company.
changing his name.
I know who I am.
Have I mispronounced your name again?
Yes, sir.
I'm not doing too good today.
Thank you, Mr. Chairman. Case 17-8.
You don't have to thank me. I can't even get your name straight.
My name's Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement. I'm presenting case 17-80000148, property in question, 322 East Lime Street, the estate of Ruby Brooks. The violation before the board is City Code 8-22, accumulation of trash on private property. Violation of City Code 40.00, parking and storage of abandoned vehicles. Should be noted, though, that the abandoned vehicle issue's been taken care of, so I'm not going to be proceeding with any other issues with abandoned vehicles.
So we're only dealing with 822?
Yes, sir, that is correct.
All right.
Going around before the board are 4 exhibits. Exhibit number 1 are all the photographs. Exhibit number 2 are all the notices, NOH, NOVs, and return receipts. Exhibit number 3 are the administrative documents, including the case history, property appraiser, and tax collector records. And exhibit number 4 is the affidavit of posting, and a copy of the sign posted. March 11th of this year, I conducted an initial inspection. Again, this one was based on a complaint on a neighboring property, and I discovered violations with this property. Initially, there was some vehicles on the property and a large amount of trash. As I stated, the vehicles have been taken care of, but there is a large amount of trash and debris on the property, both inside and outside the fenced-in area. I observed tires, yard debris, and other items at the property, as you can see depicted in the photographs. On March 15th of this year, the notice of violation was mailed first class, return receipt requested to the listed property owners derived from the Pinellas County Property Appraiser and Pinellas County Tax Collectors Database. Conducted a we did receive a phone call on March 21st of this year from a Rochelle on behalf of the deceased homeowner They advised Ruby Brooks had passed away. I found out later it was about a year ago Ruby Brooks had passed away. And the house is in foreclosure, and the family has until May 1st to vacate. That hadn't come to fruition as I'll jump ahead a little bit. I conducted the inspection yesterday. The family still appears to be living there. So moving forward, on April 6th of this year, I conducted a reinspection. I spoke to the property owner's nephew out front, and I gave him a little bit extra time until April 22nd to move those vehicles and take care of the property. On April 17th, we did get a return document, return to sender, unclaimed, unable to forward. And then, as I stated, I conducted another inspection on April 22nd, and basically at that time, there was no change. On April 24th, 2017, the notice of hearing was mailed, first class return receipt, and I posted the property April 29th. I did conduct another inspection May 10th of this year, and as I stated, the vehicle issue was taken care of, but there still seems to be a fair amount of trash and debris on the property that needs to be cleaned up. At this point, I'm asking the board to find the property in violation of City Code 8-22, and I have nothing further.
Does anyone have any questions for the officer? Does anyone care to make a motion in this case?
Did you receive this?
I would ask the clerk, as pointed out to me by Mr. Trask, any of the documents as they're passed down, if you'd please enter those into evidence.
Yes, sir.
I'll make a motion. I move based on the testimony, evidence, and facts presented and law that at the time of the alleged violation, 8-22 of the code ordinances of the city of Tarpon Springs was in force and effect. The respondent was in violation thereof.
Second.
Any discussion on this? Can we have a roll call vote?
Mr. Weeks?
Yes.
Miss Wade?
Yes.
Miss Dabbs? Mr. Bergerman?
Yes.
Ms. Casey?
Yes.
Mr. Demasis?
Yes. And now that the motion has passed and we move towards potential penalty, officer, can you give us a recommendation or a suggestion as to the city's position in regards to a potential penalty?
I think we had some prior contact where I had to get the property cleaned up before on a prior case. So I think at this point, I think it's reasonable, considering the amount of work that needs to be done, 30 days and $50 a day fine.
I move the respondent shall have until June 16th to bring the property into compliance with code section 8-22 or suffer a fine of $50 per day for each day thereafter the respondent remains in violation of said code section.
Second.
Okay, we have a motion and a second. Any discussion?
I just have a question. Since he said this property is in foreclosure and the people are supposed to vacate, then what becomes of the potential fine? Who does that shift to?
It'll stick with the property until the foreclosure is completed. Once the foreclosure is completed, the lien will be unenforceable against the property. And usually what happens is code enforcement will start a new case on the new property owner once they take title.
Any further discussion in regards or any questions in regards to this case? If not, I'd like to have a roll call vote, please.
Mr. Weeks?
Yes.
Miss Wade?
Yes.
Miss Dabbs?
Yes.
Mr. Bergerman?
Yes.
Ms. Casey?
Yes.
Mr. Demasis?
Yes. All right, that brings us to our next case. We really have a full agenda. The next case is to be established 17-800000223-967 Sunrise Drive. Anyone here for 967 Sunrise Drive? Apparently, no one's here for this particular case. Officer, if you're ready, you may proceed with your position.
Thank you. Case number 17-800000223. The address is 967 Sunrise Drive. I bring this case before you. It's currently in compliance and I requested it be established for a violation of City Code 8-40, 8-52, and 57.00, which deals with the outdoor storage of commercial goods or property. Exhibit number 1 going around are the initial photos of the inspection and the sign posting. Exhibit number 2 are all the notices, including the notice of violation and the notice of hearing and certified return, mail return receipts. Exhibit number 3 are administrative documents, including the case history, email, property appraiser, and tax collector records. And exhibit number 4 is the affidavit of posting and a copy of the sign. On April 5th of this year, I conducted an initial inspection. I had previously been out to this property and warned them about this exact same violation. And I noticed that the pallets, there was a large number of pallets stacked out at the front of the driveway and also slightly behind the fence. And I think those are depicted in the first picture. At that point in time, on April 5th, we issued a notice of violation and a notice of hearing because my intent was to bring them before the board. The notice of violation green card and certified return receipt was returned to the code office, signed by Carlos Pena on April 17th of 2017. On April 18th of 2017, another return receipt card was received regarding the property. On April 22nd, I conducted a reinspection, and many of the pallets were removed, but there was about a dozen or so that were still there, so they were still in violation at that point. I posted the property on April 29th, and I conducted a final inspection yesterday on May 10th and found the property was in compliance. And just for the record, it should be noted that all the notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collectors database. And Mr. Chairman, if you wouldn't mind entering my 4 exhibits into evidence for the record, please.
Okay. Again, I'd ask the clerk, as those items are passed down, to please enter them into the record as evidence. Does anyone have any questions for the officer? I have a question. Did Mr. Pena or anyone that you might have had contact with at this property give any explanation as to why this accumulation of pallets?
The only thing I can tell you is the first case that I had on them, I made contact with the residents, and they advised one of their roommates makes stuff out of them. I mean, that was the extent of the conversation, and nobody's ever had any other contact with me. I did pursue looking in Sunbiz and to see if maybe there was a business using that address, and I could find nothing related to that. So to answer your question, no, I don't have an explanation of why they're there.
Okay, because that's what I had suspected based on what I saw, and that's why I asked the question.
And just so the board knows, the complaint I had the first time, not this particular one, was generated by a neighbor. And then I just happened to be down on that street. Sunrise Drive is a dead end, it's cul-de-sac, so where they're at is at the end of the cul-de-sac, and I happened to turn around and went, wow, all the pallets are back. So that's what stemmed to this complaint.
Does anyone have any need for further questions for the officer? If not, I would entertain a motion in this case, and again, this is to be established.
Can we take this opportunity? We have new members down there that they don't have an idea what's going on here. The second page in here that we're going to establish, Tom, could you kind of explain to them what that's for?
Sure.
Thank you.
In your red folder, you'll see a number of different form motions. They're for different things that are happening as you board members are reviewing these cases. Some of these other board members have been here for a long period of time, and it's just kind of a matter of ease with them. But when the code enforcement officer is looking for a case to be established, what he's basically saying to you is that he issued a notice of violation. In that notice of violation, he gave the alleged violator a period of time to come into compliance.
Where did he
keep losing his
How did he approach that property initially? From a neighbor complaining because you see it? Where does that initial call?
Well, he'll testify as to whether it's a proactive complaint. In other words, he just saw it, or somebody complained. But the point that I was going to try to make here is that once he goes out and inspects the property, issues that notice of violation, property owner does not bring the property into compliance by the time that's listed in the letter. However, brings it into compliance sometime before the hearing, he still is bringing the case forward even though it's in compliance. So, and I'm just going to read one sentence from Florida Statute 162.06, paren 2. This is what the officer is doing. If the violation is corrected and then reoccurs, or if the violation is not corrected by the time specified for the correction by the code inspector, the case may be presented to the code enforcement board even if the violation has been corrected prior to the board hearing, and the notice shall so state, and the notices do state that. So if you go through the process of finding him in violation because he didn't have it in compliance within the time prescribed, and that's the motion that says at the very top that it's to be established, what happens is that even though you don't associate a fine with it this time, the next time it comes back to you within a 5-year period of time, you can have the fine start immediately upon the inspection, in other words, no compliance time, and then the fine is doubled up to $500 a day. So here, this case that you're hearing right now, this is the second one today, I guess. That's what the officer is asking you to do. Find that the property is in compliance now, but it wasn't within the time period prescribed. And if the officer believes that the case will never come back to you again, he won't be asking for it. But because of some history, he's determined that he believes that it's going to happen again. And so he wants that latitude to bring the case again at a higher fine. Wanda, did I
Thank
do
you.
okay? Okay.
I just, it's so, the first meetings that you come to, they don't know where we're reading these things from. I'll try to help you next couple of cases to just what page we're on.
Okay.
Thanks, Tom.
You're welcome.
Thank you.
Okay.
Again, I believe we were just at the point that asked for motion in this case.
Would you like to do it?
I'll go. I move based on the testimony, evidence, and facts presented and the law that the time of the alleged violation sections 8-40, 8-52, and 57.00 of the Code of Ordinances of the City of Tarpon Springs were in full force and effect at the time of the notice of violations. The respondents were in violation of said code sections, however, they now are in compliance.
Second.
All right, we have a motion and a second. Any discussion? I would ask the clerk for a roll call vote.
Mr. Weeks?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Mr. Bergerman?
Yes.
Ms. Casey?
Yes.
Mr. DeMoss?
Yes. All right, the motion passes. That brings us to our next case. And I believe
You're
that's
up.
the case that we have some people here for 119 East Lime Street. It's case number 17-800000230. And sir, would you give us your name, please?
My name is John
Laliotis,
Laliotis.
okay?
I used to be the city engineer of the city.
Okay, the name sounded familiar.
You can go to the microphone there. We can get it on the microphone.
All right, thank you. Ma'am, would you please identify yourself since you're the listed property owner?
Oh.
Just tell us on the record what your name is.
Anastasia Cavoclis.
Right. And again, sir, just for the record out loud, your name?
My name?
Yes.
John Laliotis.
And you're here as a witness, or?
I'm here to represent because she was, her English is not very well, plus I did go, inspect the property, and probably I have a company, construction company, also I'm a structural engineer, and whatever I can do to help here. Yeah.
All right.
Yeah, I don't have a problem with them. I just have a question, though, before we get started. Have you had the opportunity to review the documents that are being presented into evidence, and do you have any objection to them?
No, I don't have any objections, but I got
well,
all this about the day.
you're-
I don't know all of the
Hold on a
documents.
second. Hold on a second. We need the property owner to answer that question. You're not an attorney, sir.
Oh.
So you can't testify on behalf of her. And so I need to know whether or not she has any objection to those documents being received into evidence.
Yeah.
Yes.
No objection?
Yes.
All right, you shook your head no, so I'm going to assume that for the record that the answer is no.
No.
So,
All right, then.
She said that she has already looked at the
All right.
explained.
I don't know if he's gonna.
All right, then, officer, if you're ready with the city's position, please.
Thank you, Mr. Chairman. Case number 17-800000230. Property in question is 119 East Lime Street, and the property owner Anastasia Cavacles. I'm Officer Steve Gasson, City of Tarpon Police Department, Code Enforcement. Property, the case before you today is a violation of 8-40, which is a duty to maintain private property in the nuisance code dealing with dilapidated structures. I present to the board 4 exhibits. The photographs regarding the property are exhibit number 1 being passed around. Exhibit number 2 are all the notices, including the notice violation and notice of hearing and certified return receipts. Exhibit number 3 are my administrative docs, including case history, property appraiser, and tax collectors records and emails. Exhibit number 4 is the affidavit of posting and a copy of the sign. On April 7th of this year, I conducted an initial inspection. This house has been in this state for a significant period of time and has been the focus of numerous prior complaints. And it was destroyed by fire many number of years ago. My complaint was stemmed from the police department because we had 2 sexual assaults that occurred on the property because it wasn't as secured, and we have numerous complaints about drug sales on the property. So I went out and conducted the inspection and brought this case before the board as it is. I conducted that initial inspection. As I stated, the house is partially destroyed and it's unfit for human habitation. The rear of the house is missing a roof. Most of the doors and windows have since been torn off of the structure, and as I stated, there's fire damage inside of it. On April 7th of this year, notice of violation and notice of hearing were mailed first class with a return receipt requested. On April 13th and a few other dates after that, we've had office visits from Ms. Cavacles regarding the property and discussion about needing extensions and so on and so forth. One of the very first things I discussed and requested from her is an engineering study to see if the structure could either be rehabbed and brought back, or if it had to be destroyed based on that engineering survey. She visited the office, I think, yesterday or the day before. Still hadn't had the engineering survey, and I'm hedging my bets that the gentleman is here to be the engineering survey, I think. So that was my first step, was to attempt to get that and then determine where we go with the property, destroy it or rebuild it, and then have that done within a certain period of time. I conducted, as I stated, had another meeting with Ms. Cavacles on May 9th, and then I conducted the final inspection May 10th. And all of my notices were derived from the Pinellas County Property Appraiser and Tax Collectors database. And as you can see in some of the pictures, especially the very first picture that went around, they have since installed a large 6-foot privacy fence completely around the structure, front and back. All of the windows have been boarded up, and to the best I could tell, the doors as well were boarded up. So it appears to be fairly secure, with the exception of the roof. Now, an interesting caveat to this, because I just can't bring boring cases before the board, Mr. Crow, who was just here, had successfully got a final order of judgment against the property. She presented that order, and I don't know if I have it but basically, she has a judge's order that within 200 days, and I don't have the exact date, that property is to be securely boarded up, fenced, and as a matter of fact, I do have the final judgment as one of the exhibits. He stated the defendant is hereby ordered to fully fence all sides of the subject property with a 6-foot fence, permanently and completely board all windows, doors, holes, and roof at the subject property so as to make it impenetrable by any other persons within 200 days. And on April 17th, it was signed by Judge Thomas McGrady, Circuit Court Judge, Pinellas County. So there's been some other action with this, which is basically along the lines of what the city's asking for. One of the issues the city has, though, is part of that ordinance says you can't board up a structure. You know, it has to be properly windows or whatever the case may be, but it does say in the ordinance that boarded up buildings are not allowed. So we're at a weird place because the county court judge is ordering it to be boarded up, and this would be one of those things what I probably would have asked Tom about previously, but I didn't have a chance to. But I wanted to make sure the board was aware of the court order. So at this point, I have nothing else other than requesting the city find them in violation of 8-40 as well. So we're kind of running parallel cases here.
Ma'am, do you have any questions for the city's witness?
Appreciate he give me the extension for fix. That's all I need.
Okay. I think we have a language barrier here.
Yeah, she says she likes to have an extension to fix these problems from this house.
And what type of an extension are you requesting?
To make it 6 months.
What about this order we have from the court for 200 days? Is that still in force? Or?
I don't think we really have anything to do with that order. That's a court order from a different court. This is a city situation.
I like it 60 days. I'm sorry, 6 months, please. Appreciate so much.
Okay.
Appreciate everybody. That's all.
Yes, Allah.
No questions for Officer Gasson?
Everybody, very good. The gentleman there, everybody, I'm very happy.
All right. Do any of the board members have any questions for the officer?
I do. What exactly needs to be done to bring it into compliance? Because I'm a little confused because of the boarding up.
Well, step one would be getting the engineering survey, because if the engineering survey says the house can be rehabilitated, then the city's position would be to rebuild the house and get a certificate of occupancy issued for it and make it a viable structure. If the engineering survey comes back and says the house is not viable and needs to be destroyed, then the city's position was we would want the property owner to demolish the property. So that there's two choices. Step one all kind of derives from that engineering study to determine if the house is viable or not. And then you make the determination from there. Property owner can certainly just demolish it, even without the engineering study, but that's solely on them. And that would put it into compliance because it's no longer there.
Any other questions for the officer?
I do. Do you have any concerns about, you've already stated that the house the property is dangerous. There's crime that has taken place there. Now is that crime going to take place behind a fence where we can't even see it?
The interesting thing was I went by and inspected the property shortly after the fence was installed, and part of the back was already peeled off. I made Ms. Cavicles aware of that in the office when she visited me. I don't know. I honestly haven't been back there again to see if anything's been done. Historically, fences are torn down frequently, so it's going to be incumbent upon her to keep those up. The fence is not so much satisfying the nuisance ordinance. That's just a safety issue. So I really honestly can't answer that question if somebody's going to tear part of the fence down or not. So.
Okay, I don't mean to be dense, but it's not just a survey. It's either it needs to be fixed up or torn down.
Correct.
Okay, and so 6 months isn't really too much time.
She's got a standing court order that says 200 days to at least take care of the roof, which is going to be issued 6 months, 180 days, and this was April 17th of the court order. So 6 months puts us right about that same time. So they're going to run about the same time. But the city's a little more restrictive in the sense that we don't allow the boarding up of the buildings per se in our ordinance. So the first step is going to be what I've asked her to do now for over a month is to get an engineering survey to determine the viability of the property. And then from that point, she's got two choices, but if the engineering survey says it can be rebuilt, those same two choices exist: rebuild it or destroy it. If the engineering survey says can't be rebuilt, then there's a option, and that's destroy the property and demolish it.
Feeling fixing it up.
I don't want to get into to being on record as to being making a decision on that.
All right. Let me ask you, ma'am, are you ready to present your position?
What did you say?
I'm asking Ms. Cavalikas if she would present her side of the question. Do you have anything that you'd like to put on the record, ma'am?
There's a piece to put there.
Me?
Yeah.
Yes.
No, just to extension and start and finish. His engineer is here.
All right, then let me ask you, sir, do you have anything that you want to put on the record?
I don't, I see the property, I went a couple of times and looked at. There's a lot of work has to be done, but still, is a lot of smoke in the house. It's not destroyed completely. In my opinion, it can be rebuilt, not destroyed, not demolished. If this board says they okay, we can apply for the building permit, and we'll start in 6 months. Will be very completed. That's my opinion.
Officer, any questions?
Yeah, hang on 2 seconds. I have a question for the gentleman. He presented a letter at the beginning of. Yeah, I don't believe he presented it to the board though, regarding the property and his professional experience. His letter is as a consulting engineer, dated May 11th. Said, "Dear gentlemen, with the letter we've informed you that we have come to an agreement with the owner of the above referenced property to do plans if needed and finish the construction and repairs of all affected areas damaged by fire. All work will be to applied codes of the city of Tarpon Springs, Pinellas County, state of Florida. An application has been obtained to the building department, which will take place on May 11th. So my question, sir, based on this letter, have you obtained a building permit?
What's that? I'm sorry?
Have you obtained a building permit, as you stated in this letter you were going to do?
Yes, I'm going to do that, yes. Sir.
So you have not done it?
I don't understand, sir.
The letter says that you'll have obtained a building permit by May 11th.
No. I will be, after the meeting, we apply for the building permit.
Can you read the letter again, please?
Sure.
What's the date of the letter?
Today.
Okay.
It says, "Dear gentlemen, with this letter, we have informed you that we have come to an agreement with the owner of the above referenced property, 119 East, he has it as 119 East Lemon Street, which is incorrect, to do plans if needed and finish the construction and repairs of all affected areas damaged by fire. All work B2 applied codes of the city of Tarpon Springs, Pinellas County in the state of Florida. An application for obtaining the building permit will follow after the meeting, which will be closed, but will take place at the City Hall on May 11th, 2017. Your help at resolving this problem is appreciated," and he has his phone number and his signature, and if it pleases the board, we can enter it as evidence on his behalf. I have no objection to it.
I think we need to put a copy of that in the record.
You can go ahead and put it in there. He has one as well, I guess. Either way, I don't mind submitting it, or he can submit it.
I gave to this lady, but I have another copy here to give it.
All right, so we have a copy. Can we?
Realize the address is incorrect.
What's that?
The address on your paper is incorrect.
Oh. Is it correct?
Yeah, the address in the letter says 119 East Lemon Street. It's
Lime.
East Lime Street.
We'll get it.
Oh, I'm sorry.
Are we talking about?
We can, right now, we can correct it.
All right, I just want to make sure it is
We're talking about the right.
Lemon Street, isn't it?
Lime.
I'm sorry, yeah.
Excuse me, Lime Street. It's Lime Street, right?
Lime Street.
Lime Street,
Yes,
all
sir.
right.
Yes.
Yeah, tomorrow morning, is that all right?
This copy?
Sir, if you could just hand that document to the board member here, since you're turning it into evidence, and we'll pass it down for every board member to review.
No, this one? Yeah.
Does anybody on the board have any questions? Anything else that you want to add before we go to questions? Anything you want to add?
No.
Just expensive, and appreciate very much.
That's all. Yeah.
All right.
You can ask him that question.
Are you currently licensed? You have a license number on there. Is that in force at this time?
Yeah, I have my license down there, below my signature.
That
Yeah.
gives me the number.
Yes.
Is there an expiration date on that?
No, it's a couple more years.
I didn't hear what that question was.
The question was, is he still licensed? And the gentleman indicated that he's still licensed. The license is in effect for a couple more years.
Thanks.
ask the clerk if you would make that letter a part of the record when it's passed down.
Yes, sir.
All right. Anybody have any further questions for Ms. Kavlou?
Kavukis.
Pardon?
Kavukis.
Cavaples. All right.
Mr.
I'm a
Chairman?
Greek, but I'm having a hard time with that particular name. So,
Mr. Chairman,
yes,
could I ask one more question of the
certainly. Go
gentleman?
ahead.
Are you certifying that the property can or cannot be rebuilt at this point?
We can't be rebuilt.
Okay,
yes.
so you're willing to submit an engineering report stating that that property can be rebuilt to the board?
Yes, I can do that.
When can you do that?
But when is needed? This week, the next week, for example, Friday today.
Okay.
Right. Well, you need a letter for
You
me
can
to
send it
say-
to my office. I'll make sure it gets to the proper folks, but I'd like to see the engineering report.
I mean, what kind of report, sir? You going?
One where you're certifying based on your license that
Yes.
that property can be rebuilt.
Right. A letter. You need a letter from me.
The letter
Sign
doesn't
and
say
seal,
anything
right?
about that. It says you're willing to work with her, but it doesn't say you're certifying that that building can be rebuilt. That's
I
what I'm
will do
asking
that.
for. Okay, thank you.
You will.
I have a question for you,
Yes,
sir. Or to either one of you. If in fact the engineering survey is made and it's shown that the house can be rehabilitated for occupancy, is there an estimate as to how much time you would need to do that, accomplish that? I know that there's been a request for 6 months, but what would be the absolute minimum that you would?
Well, 4 to 6 months. You know, maybe we push it. We have 4 months. We can finish.
Does anybody have any questions for either side in this case?
I
I have a lot of concerns about this, but I don't want to raise this.
You have what?
I have a number of concerns
Well,
about
then, if you have any questions, go right ahead and ask them. If you want to discuss it with the board, then we'll have to wait until there's a motion on the table. But if you have questions for either side, please go right ahead and ask them.
Are you are applying for you're going to certify that this is buildable within a week,
Right.
and you're going to apply for a building permit at what time?
After that, May next week,
With building to commence immediately?
start, yes. We start the building after we got the permit. I don't know how long will take the city to give us the permit. But right now, I have something else to ask. This coming summer, a lot of people going on vacations and a lot of things, and I'm going to leave on July the 15th. She's coming back the end of August. That's why I would appreciate if the time-wise, we don't have to come back to you and ask if you can give us more time to finish it.
Well, okay, that may very well be a big issue. Does anybody have any further questions? Does anybody want to make a motion in this case?
I will.
Go ahead then, please.
I move based on the testimony, evidence, and facts presented in law that at the time of the alleged violations, section 8-40 of the Code of Ordinances of the City of Tarpon Springs was in force and effect. The respondent was in violation thereof.
Second.
Now, do we have any discussion on this case? Ms. Wade, you indicated that you had some concerns. I'm not sure if they were rectified during your questioning of the witness, but if you have anything that you'd like to bring up for the board for discussion, go right ahead.
And again, I'm new at this, but I just don't have assurances that anything's going to happen.
Yeah, that's, so your duty or obligation is to determine whether there is a code violation, and if so, establish a time and a fine. If you believe that it's going to take them a long period of time and you don't necessarily agree with that, then you can put whatever time that you think is appropriate based upon the circumstances of the case. And as for the dollar amount of the fine, you can, levy a fine anywhere from $0 to $250 a day for every day that the property remains in noncompliance. And when you look at that, the dollar amount of the fine, you're supposed to look at the gravity of the violation, how serious it actually is, what attempts that they've made to bring the property into compliance since the notice of violation has been issued, and whether or not that they've been cited in the past for violations, that can also be taken into consideration, but that's how you figure out the dollar amount of the fine. So give them a period of time and set the dollar amount of the fine, and that's done in the second portion of the next motion that will be made. That's how we're going to address it then. So right now, this motion is, are they in violation or not in violation?
Any other, is there any other discussion amongst the board members? Can I ask for a roll call vote from the clerk, please?
Mr. Weeks?
Yes.
Miss Wade?
Yes?
Ms. Dabbs?
Yes.
Mr. Bergerman?
Yes.
Ms. Vaquesi?
Yes.
Mr. Demasis?
Yes. Okay, the motion having passed, before we go on to discuss whether in fact there should be any penalty, I would turn to the city's representative officer. Any comments or suggestions in regard to this particular case that you brought before us?
Thank you, Mr. Chairman. Yes, I would agree with the 6 months, and largely that's because there's a standing court order by a judge that runs along about that same period of time. The other thing I'd like to bring before the board is I have a number of prior cases. I can tell you from 2010 forward, at least 10 cases on this property. I've worked here 20 years. I can't remember exactly what year the house burned up, but it's never been dealt with. It's always been an issue. I can't explain why my predecessors never brought cases like this before the board, but as you can tell by today, that I have quite a few properties that are in bad shape and need to be dealt with. So for the reason, only thing that has caused any action to occur is my notice of violation and notice of hearing. The fence got put up, which does significantly help, hopefully, to keep people out of it. But I think 6 months is reasonable, only commensurate with that, the judge's order. But with that being said, it either needs to be demolished or it needs to be rebuilt, and a certificate of occupancy needs to be issued for the city to find it in compliance within that 6 months. And at that point in time, primarily based on the priors, I would ask for $100 a day.
All right.
Okay. I move that the respondent shall have until the 10th of November 2017 to bring the property into compliance with Code Section 8-40 or suffer a fine of $100 per day for each day thereafter the respondent remains in violation of said code section.
Second? Any second?
Annie did.
Annie did.
I'm sorry, Annie, I didn't hear you. Annie seconded, okay. Any discussion? I would just point out, based on the testimony of the officer, that perhaps the $100 fine would be a good incentive to work against that 6 month deadline, which was indicated as the time frame. So, and again, particularly in view of the fact that this house had burnt quite a matter a long time ago. So, we'll hopefully things will work out. So I certainly would suggest that we support the motion. Can we get a roll call vote?
Mr. Weeks?
Yes.
Miss Wade?
Yes?
Miss Dabbs?
Yes.
Mr. Bergerman?
Yes.
Ms. Vaquesi?
Yes.
Mr. Demasis?
Yes. And Mr. Trask, if you would please sum up the Code Enforcement Board's
I'd be happy to.
decision.
Ms. Cavacles, you've been found in violation of Section 8-40 of the Code of Ordinances of the City of Tarpon Springs. You've been given until November 10th, 2017 to bring the property into compliance. Should you fail to bring the property into compliance by November 10th, the city is going to be levying a fine of $100 a day for each day that the violation continues to exist. Okay?
After 6 months.
After November 10th.
Okay.
Okay?
Yes, sir.
Once the property is brought into compliance, I'd ask that you call Officer Gasson, have him come out and inspect the property. And then if it's in compliance, the affidavit of compliance will be issued.
Thank you so much. I appreciate very much everybody.
All right,
Thank
well,
you
you
very
asked for 6 months, you got your 6 months, so hopefully,
Thank you.
you're entirely
everybody.
welcome. Hopefully, the situation will rectify itself. All right, that brings us to our next case. It's case number 17-800000231, 514 East Lime Street. Anyone here for 514 East Lime Street? All right, apparently no one's here. Officer, if you're ready, you may proceed.
Thank you, Mr. Chairman. Case 17-8000231, 514 East Lime Street, property owner listed Pierre Fowler and Tiffany Coleman. Again, I'm Officer Gasson, City of Tarpon Springs Police Department Code Enforcement. This again is another dilapidated structure that I am requesting the board find in violation of 8-40 under the nuisance code. Initial inspection was conducted on April 8th of this year. The structure was severely damaged by fire many years ago. I want to say at least 8 years ago, approximately. And it as well is unfit for human habitation. Additionally, somebody's tried to begin doing some work on the property, and that was in the absence of a permit. A stop work order was issued. I had initially had a case on this, but I referred it over to the building department, but nobody at the building department had done anything, except they did issue the stop work order for us. So that was about it. And it's gone no farther within the city, so I basically opened up another case to bring before the board. I passed around 4 exhibits. Exhibit number 1 are photographs of the property. Exhibit number 2 are all the notices, including the notice of violation and the notice of hearing and the certified return receipts. Exhibit number 3 are administrative docs, including the case history, tax collector, and property appraiser's records, letter from engineer David Ramsey, and an affidavit of posting and copy of the sign is exhibit number 4. As I stated, April 8th was the initial inspection, and then a notice of violation was mailed first class and return receipt requested to the listed property owners via the Pinellas County database, property appraiser, and tax collector. On April 13th, we did receive a phone call from a female speaking on behalf of Pierre Fowler. She stated that there had been an engineer out there, and they do plan on rebuilding the home. We asked to have a report from the engineer, and she would be required to get a building permit and go through the proper process. On April 17th of this year, the certified return receipt for the notice of violation was received. That was the one that was sent to Pierre Fowler. And then on that same date, the one for Tiffany Coleman was received as well. April 18th, the notice of hearing was mailed first class, return receipt requested to both owners on record. On April 24th, we did get a letter from Engineering Corp dropped off to the Engineering Corporation dropped off to the code office. They advised in the letter that a plan is being developed to replace the house or replace the old structure. More time was requested, but a specific timeline was not provided. And then the letter is attached as well. On April 24th, the certified signed receipt for the NOH for both property owners was received in our office. On April 29th, I posted the property. And on May 10th, I conducted a final inspection. There was no change. It basically still stands as the photos depict. And at this time, I have nothing further.
All right. I'd like to point out to the clerk, as the documents are passed down, if you please make them part of the evidence for this case. Anybody have any questions for Officer Gass?
I have a general question looking at these cases you brought today. Some of these are old, some of these places have been in bad shape for a long time. What is the remedy to the residents who have to look at this all the time?
At this point,
We couldn't hear you.
He's brought a number of cases where these eyesores, for lack of a better term, have been sitting there for years, meaning their neighbors have had a look at that. What is the remedy to these neighbors sitting there for all these years?
to answer your question, I'm bringing them before the board so that I can actually get some finality and we can move forward with a legal process that may need to occur. With them just sitting there as they are, there's absolutely nothing that's going to occur, with the exception of the prior case where a final judgment was issued by a judge based on somebody asked for injunctive relief through a court order to have certain things done to these properties. This is my 2 years, which isn't an extensive time. I'm sure Mr. Trask has seen them before, but that's finally the first time I actually saw somebody get a court order to do something. But with that being said, I'm bringing them before the board so that it kind of starts the pathway for these houses to be dealt with by the city if need be. We obviously would prefer that the homeowners take care of these properties themselves. And then hopefully by bringing the cases and the board finding them and assessing a period of time and potential fines, these property owners will take care of these properties so that the neighbors don't have to deal with them and they're not a health issue, a safety issue, or an eyesore. Hopefully that answers your question.
It does, but it still concerns me that these have sat there for years and nothing's been done.
You know, the only thing I can think of is if I lived next to that, I'd have been complaining. And evidently it doesn't bother them because they didn't complain.
I may be just creative. I don't know. I feel that there's an ordinance that covers this. I'm surprised it had never been used before. I can't explain why.
Okay.
But now that I'm in the position, I kind of plan on wanting to do something about these places.
All right, does anyone have any further questions in regard to this particular case? Any other questions for the officer? Can we get a motion?
Mr. Gaston,
Oh, I'm sorry, go ahead.
can I ask you how many complaints that you know of that you've gotten from the neighbors in reference to this building?
I don't specifically know. I know I had done a previous case on it in 16 because what started is it was being used as a dump. Literally,
Yeah.
it was a dump. And so I had opened a case up, and as I progressed through my career and knowing this job, I've learned new things as I've gone along and started to read the ordinances and realized that there was a solution. So unfortunately, I didn't take care of it on the prior case in 2016 because I was really still kind of new and didn't understand I had the ability to do that.
Right.
As I stated, so now we're at the position where I'm a little more comfortable. My feet have been wet, so to speak.
Anybody else have any further questions? There being no further questions, can we get a motion? Anybody care to make a motion?
I move based on the testimony, evidence, and facts presented in the law that at this time, the alleged violation section 840 of the Code of Ordinances of the City of Tarpon Springs was in force and effect. The respondents were in violation.
All right, do we get a second?
Second.
There's a motion and a second. Any discussion among the board? All right, no discussion. We'll go directly to a vote. I ask the clerk, please make a roll call vote.
Mr. Weeks?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Mr. Bergman?
Yes.
Ms. Fay Casey?
Yes.
Mr. Demosis?
Yes. Okay, the motion passes. That moves us to the potential penalty phase. But before we do that, I would turn to Officer Gasson, now that I've got your name straight, hopefully. Officer, any suggestion or recommendation on the part of the city in this particular case?
I think along with the other ones, it's probably reasonable to look at. They do have the engineering report, and they're stating a plan is being developed for a solution to the existing structure, and that was April 14th, which is now past 1 month. I would say that I think it's reasonable. I would ask for 4 months. I know that sounds kind of interesting, but they've already had a month go by to work on it. So I think 4 more months, based on what the prior gentleman was saying, who's apparently some sort of an engineer, he could rebuild a house in 4 to 6 months. I think 4 months is reasonable. They should have already had some of that groundwork laid, and then based on that, $100 a day fine after that.
Any discussion among the board members? Well, wait, let's see. We need a motion. Anybody care to make a motion in this case?
Yeah, I move that the respondent shall have till September the 11th, 2017 to bring the property in compliance with code section 8-40 or suffer a fine of $100 per day for each day thereafter the respondent remains in violation of said code section.
Second?
Second.
All right, we've got a motion and a second. Any discussion among the board? Then I'll ask for roll call vote, please, from the clerk.
Mr. Weeks?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Mr. Bergerman?
Yes.
Ms. Vacasie?
Yes.
Mr. Demosas?
Yes. And the motion passes. That moves us on to case number 17-800000244, 722 Merlin's Court. Anyone here for 722 Merlin's Court? Apparently not. And this is a case to be established. We'll turn to Officer Gasson. And if you're ready, sir, you may present the city's position.
Thank you. Case number 17-800000244. The address is 722 Merlin's Court. The property owner listed is James R. Bauer. This case I bring before the board, it is currently in compliance, and I asked for it to be established. The primary violation is 8-40, which is duty to maintain private property, which deals with lot maintenance. There's 4 exhibits going around. Exhibit number 1 are my photographs, the initial inspection, the posting, and the final inspection. Exhibit number 2 are all of my notices, including the notice of violation and notice of hearing and certified return receipts. Exhibit number 3 is my administrative documents. And exhibit number 4 is the affidavit of posting and the copy of the sign. Initially, I inspected the property on April 18th. The lot was overgrown. There happened to be a Brazilian pepper tree in front of it right by the main door. On April 18th, the notice of violation and the notice of hearing were sent via first class. Return receipt requested to the listed property owner via the Pinellas County Tax Collector and Property Appraisers Database. April 29th, I posted the property. On May 10th, I conducted an inspection and it was in compliance. Should be noted before the board that I personally have had 2 prior cases for the exact same thing. And looking through our prior records, there's approximately 10 or so where this gentleman doesn't seem to want to take care of his yard. The primary purpose to bring it before the board is so that he becomes a repeat violator and hopefully influence him to take care of his own property without the city having to expend the time to do so. And at this time, I'd like the board to find him in violation of 8-40 of the city code. And I have nothing further.
Does anyone have any questions for Officer Gasson? No questions? Does anybody care to make a motion? And I'd like to point out to the clerk, please add these photos and documents to the record as evidence as they're passed on.
Yes, sir.
Anybody care to make a motion?
I
in
move,
this case?
based on the testimony, evidence, facts presented in the law, that the time of the alleged violation, section 840 of the Code of Ordinances of the City of Tarpon Springs, was in full force and effect. At the time of the notice of violation, the respondents were in violation of said code section. However, they are now in compliance.
Second.
Okay, we've got a motion and a second. Any discussion?
Officer Gasson, we're, on this particular one, it's just 8-40, not 8-40 and 8-52?
Let me look, because typically this, I would have imagined, would have been an 852 as well, but I think it was just strictly. Oh, yeah, I'm sorry, it was both, so we probably have to amend.
I'm sorry,
It was 840 and 852, I'm sorry, my notes, I forgot to write 852 on there, I apologize.
Okay.
All right,
But the motion went in as 840 and 852, is that correct?
Right, now we're on the second motion.
Right, okay.
So now we're dealing with the penalty phase of the first one.
And we can do it under.
Established.
This is
Oh,
an
this is
established
establishing,
violation.
okay. You're right, I'm sorry.
Okay, so we just have to vote on-
Amend your
I'd
motion.
like
motion to
amend my
add him.
motion to include
8-52.
8-52 as well.
All right, so we have the motion corrected, and can we have the corrected motion seconded?
Second.
All right. Any discussion on this, or can we go right to a vote? Apparently, there's no discussion. Then I would ask the clerk for a roll call vote, please.
Mr. Weeks?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs? Mr. Bergerman?
Yes.
Ms. Vacasie?
Yes.
Mr. Demosas?
Yes. Okay, that brings us to affidavits of non-compliance.
Excuse me, can I have the rest of the evidence, please. I
I'm
don't-
sorry.
It's okay, I just don't want to lose nothing.
All right. That brings us to the affidavits of,
Don't we need to make the second part of the last one?
No,
Motion
that
for
was just to be,
repeat
just to be established, and so there's only that one motion to be made. When it comes back the next time as a repeat violation, you would be using those other motions that you've got there.
I'm sorry, I just gotta learn it.
Yeah, that's no problem.
all right.
A lot to learn.
Especially, it's gonna take me a while. How do we get a copy of the ordinance? I can read it.
They're in the paperwork and they're in the code book, and they're online too.
Oh.
I'll give you the website you can get into.
This is the only.
So they just need a motion to accept the affidavit of non-compliance in this one, and then on this one, they're gonna need an affidavit, a motion to approve the affidavit of non-compliance and prosecution. For some reason, they didn't include.
Right, okay, that's what threw me.
Yeah.
All right, we have in front of us the affidavits of non-compliance. Does anybody want to make a motion in regards to affidavits of non-compliance for case 16-800000582 and case 17-800000143?
I will be happy to, but I'm not exactly sure how I'm supposed to do this. Is this gonna be one reading for both of these cases?
No, you need to do them separately.
Separately, I'm sorry, then, all right, let's do it separately, and I stand corrected. Thank you, Mr. Traskins.
We can do the affidavits of compliance altogether.
Right.
Okay.
But because they're asking for prosecution costs on the second one, I think it'd be best if we separate them.
Absolutely.
All right, so the first one there isn't. Well, you guys clear down there. This is further on back in the book. We just have to accept these affidavits at the end of every meeting, okay? I move based on the testimony, evidence, and facts presented in law that the respondent failed to timely comply with the board's prior order within the time prescribed and to award this. Okay, here's.
Time prescribed, period.
Okay, the time prescribed.
And that you move to accept the affidavit of non-compliance.
And I move to accept the affidavit of non-compliance.
Right,
Second.
All right, can we get a vote? All those in favor say
Aye.
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 Aye. All those opposed say nay, and the ayes have it. That brings us to our next affidavit of non-compliance, and this one includes a
amount
prosecution cost of $179. This is case number 17-800000143, 316 East Boyer Street.
Okay. I think this thing needs to be rewritten a little bit because there was no place for me to give the case number on the previous one. Okay. I move based on the testimony, evidence, and facts presented in law that the respondent failed to timely comply with this board's prior order within the time prescribed and to award the city $179 for the costs incurred in the prosecuting of this case.
Is there a second?
Second.
All those in favor say aye.
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 All those opposed say nay. And that passes. That brings us to affidavits of compliance. We have affidavits of compliance for two cases. I believe we can do this jointly.
Yes, sir.
All right, it's case number 17-800000125 and case 17-800000145.
Okay, I move to accept the affidavits of compliance in case number 17-800000125 and 17-800000145.
Second.
We've got a motion and a second. All those in favor say aye.
Aye.
All those opposed say nay, and the ayes have it. That takes care of it.
Mr. Chairman, did you cover the prosecution affidavit? Miss it.
Yes, we covered it.
Okay, I just missed it. Thanks.
$179 awarded to the
That's the oh my God, sorry.
Okay, is there any old business?
new, but I don't have old.
Okay.
I got a thing.
All right, I asked for old business, apparently there's none. Any new business?
What?
I had asked just for some date changes. I believe you were all emailed. I have some schools coming up, so I'm asking the board to consider our June meeting to be moved to June 29th and our July meeting to be moved to July 20th. And then we would resume the second Thursday in August on August 10th.
Okay, is there anybody that objects to that or has any comment they'd like to make?
Could you give me the dates again, Steve?
The dates would be June 29th and July 20th. Your secretary said you were okay with it.
Does that tell you something?
Yes.
Okay.
I have that email too.
Okay. I do have a comment, Mr. Chairman. That works out great for me because I was scheduled to miss the July 13th meeting. Now I wouldn't have to miss the July meeting.
Well, that's good then, because you've been my right-hand man. Well, actually my left-hand man. You're on my left
Hope I
side.
haven't bruised your shin too
No,
much.
no, I appreciate it. Although I probably should have been kicked a few times. All right then, so we're all under the understanding that the June meeting will be June 29th. The July meeting will be on July 20th, and that helps out Officer Gaston. And since I've mispronounced his name for the last several months,
Plenty of time to practice.
I'm glad to know that we can do him a little bit of good. So that'll be that. Any comments? Any public comments or any comments from the board? Any?
I'd like to meet our new members.
Okay, let's do that. Let's welcome our new members, and we'll start with the gentleman on the end. Sir, if you could introduce yourself, tell us a little bit about you.
Hi, my name's Tom Weeks. I'm retired. I was a yacht broker for the last 11 years here in Tarpon Springs. And I have lived here for the last 11 years. My wife and I bought a house over on Lincoln Avenue 2 years ago. And Officer Gaston, I just want to say thank you for taking care of these things that need to be accomplished in a robust way.
You're welcome. Thank you. I appreciate it.
And next, ma'am.
I'm Julie Wade. We actually met at the Citizens Academy. Thank you to the City of Tarpon Springs. That's a fantastic program. And just some of the stuff just sticks in my craw like it does yours, and so I'm glad we're getting to it. I'm a Florida native. I grew up in Panama City, and I came to Tarpon Springs after a brief hiatus of 30 years in Minnesota and came back here in 2005.
Well, we all welcome you both to the board, and after one or two sessions, you'll pick it right up, and I really appreciate you taking part.
This was a long meeting, are they?
It was. Some of them are 20 minutes and we're out of here.
We actually, before I became chairman, we actually had one that lasted 9 minutes, and I continue to look forward to breaking that record, but I don't know.
Gotta talk faster.
I don't, well,
We're not allowed to discuss anything outside of this?
No,
They're
there's a
taking what we
sunshine
get.
law here in Florida, so you want to be very careful that everything has to be out in the public. We want to make sure that we comply with that. So,
We didn't get that yet, so I wanted to make sure I understood.
okay. Well, you're probably going to be asked to go to a training class. I would not be surprised that,
Oh, for
that,
Pete's
well, it's the price of,
No, they just, that's fine.
but you will no doubt get some instruction on that. I believe most of us have been through that, but there is a sunshine law here in Florida, so we don't want to have any discussion outside of what occurs on the record.
There is a video on the sunshine law on the city's website, by the way. You can look at that video.
It's not particularly long, and it may very well be informative. Okay, any other comments? I appreciate everybody today. We went a little long, even though I tried to cut out the lawyers by not allowing them to speak, okay? Which is impossible. Is it not, Mr. Droz?
I'm sorry, I was talking to Mrs. Wayne, so.
All right, then. Thank you very much. The time is 4:37, and we're adjourned.
I thought we were going until 5:30.
Well, I was going to look at that clock and make it 10:10. It feels like 10:10.
Go on this website, and you can find the city code. Before you can go on the city's website itself and find the code. and we can look at the code sections as they apply in particular case.
I appreciate it. Thank you very much.
My name and phone number, I'm the city, one of the city attorneys. I've been representing this board for over 20 years. Okay? And this is my specialty, I represent 10 municipalities. That's my email address if you have questions. And,
Oh, all right. Nice to meet you.
yeah, I smile.
Thank you.
Okay.
I
All
represent.
right. Well, we're getting there.
Okay, I will represent the city. I represent you.
Yeah, can you possibly bring us a shorter docket?
I wanted to show you that
The
provision
dockets
of
were
the
nice
code.
and short before I became
Statute that
vice
says
chairman.
that,
They've been getting longer ever since.
It's funny because some of the stuff I do.
you should separate yourself from bringing these cases forward.